Good evening to everybody. Welcome to the today class of the Advanced Private International Law. That in the last week that I was somewhere and I could not make it out. At least this week that I can want to make it out. My class. This is okay. Now you could able to see that what I posted on the screen. Can anyone can unmute and read what I posted on the screen? Please, why it is going? Yes, anyone can unmute and speak what I posted on the screen. Hurry up. Anyone can unmute and speak what I posted on the screen. Dorcas, you read. Unmute and read. Anyone can unmute and read.
Theories of Private International Law.
Go ahead.
Online virtual class by Professor Mohammed Saheb Hussain, Professor of Law, School of Law, St. Augustine University of Tanzania, Mwanza, Tanzania, East Africa.
Okay, other people should have to mute. Whenever you want to speak, at the time only you unmute it. Isaiah Malago, I could not see your microphone. But anyway, let us come to the point. Our study is because we are dealing about the theories and I completed the above theory where I say the gay marriages are allowed in some places and some places it not be there. So that is about the criticism of the statute theory is concerned. And now that I am going to deal the international theory. So this theory is also known by the name of the founder Von Savigny, and he is the propounder of this theory. And the German jurist is completely rejected the statute theory, and he will not follow the statute theory. And he said it is completely outdated, obsolete, and doesn't suit to the private international law. And hence, he has in his book Conflict of Laws, published in 1849, and he termed the statute theory to be the incomplete and ambiguous. That's the word that he used over there. So Savigny, what he advocated, more scientific method by saying that the problem is not to classify the laws according to their object, but to discover for the every legal relation that local law to which in its proper nature it belongs. So according to this theory, they say that let we consider the local laws also. Each legal relations have its natural seat in particular local law. So local law means the municipal law, and where the case is admitted or case is filed. And okay, later we'll see it. Okay, and a practical local law, and it is that which must be applied then differ from the law of the forum. Then the question comes: the law of the forum. Sometimes we cannot use it, but the local law of that place where the law, lex causa is there, that law can be used over there. But in other words, we can say that lex loci will be replaced by the lex fori. So here the seat is the place where the thing is situated in case of a person where he is domiciled. So if the matter comes to the immovable property is concerned, that we use the connecting factor lex situs, and when the movable property is concerned, that we will use the person domicile. It plays an important role in the movable property. So that is the thing. The most outstanding merit of this particular theory is that he tries to decide on each conflict how he can manage it. Okay, it is gone over there. Okay, let me scroll down. Yes, on the basis of the circumstances and most relevant set of laws, it supports the application of laws that the legal system to which the parties' things are concerned naturally belong to. So according to this theory, let us see what is the application of the international theory. To determine the natural seat, Savigny has explained four principal determinants. So his variables are four. Depending upon that, we can establish that international law theory would be very suitable for the conflict of laws. So let us see the first one. Yes, I would like to see whether my LLM students are participated or not. Dorcas, can you read it, what I highlighted here? Unmute and read.
The domicile of a person affected by legal relation.
Okay. Second.
The place where a thing,
Read.
the place where a thing which is the object of legal relation is situated. The
Okay.
place where a juridical act is done,
Mhm.
and the place where a tribunal sits.
Very nice, very nice. I appreciate. So these are the things would be there where it can be made and how it can be made. We can manage it. So now number one is concerned the domicile of a person affected by the legal relations. So what is the domicile of a person by the legal relationship? How it can be plays an important role. That is the first one. Second, the place where the thing which is the object of a legal relation is situated. Suppose the mobile property or immobile property where it is situated over there, even that also a determinant factor. And the third is the place where a judicial act is done. And here the judicial act is done in the sense either the right or the case is filed. Both are the things. The juridical act is done, but here the juridical act means actually the act is done over there, the more important factor. The fourth is the place where the tribunal sits. So these are the four determinant factors are there. By that we can say that which country law would be applicable according to the international theory. Now let us see that how it can be made and how it can be applied. These are the four determinant factors are there. It is a natural that every legal relationship there has to exist some form of a contractual agreement between the parties involved. Naturally, what is the legal relationship would be there unless until the parties are involved in a contract. I'm not speaking about the blood relationship here. Here, legal relationship in the sense if there is any contract between the two parties or not, that is the more important factor. Is it clear? Say yes or no. Is it clear? Legal relationship is different from the blood relationship. Here, there would be a band of the legal relationship because there is the involvement of the parties for the contract. So that is the legal relationship will start. When you come to the blood relationship, it comes through the siblings, father side, mother side. So that the blood relationship is there, or we can say the consanguinity also. So in the case the law ought to be injustice to either party involved in such an arrangement, a legal recourse has to be sought. So what is the legal relationship would be there? That is a very important factor to determine to use the international law theory. Now next, in the case of the domicile of a person affected by the legal relations. So the domicile of a person, again it comes to the point, because the legal relationship is there between the two parties, but when the domicile of a person of one of the party will be taken into consideration when the matter comes to the mobile property. So we should rather insist on the domicile of the parties to the contract, where the contract took place, and where the breach was committed, and where the court for settlement of the dispute sits. If the subject of the dispute is land, then automatically say land is a immobile property. Hence, lex situs will govern the contract, even if it differs from the domicile of either party of the both the parties. So here he says, depending upon the legal relationship, sometimes the legal relationship will be not considered over there, but the domicile would be considered over there, because that is the same thing which is made here. So domicile of a person affected by a legal relations. We should rather insist on the domicile of the parties to the contract. If the two parties are there, what is their domicile? We should have to give the more concentration. Where the contract took place. Number one, domicile of the person. Number two, where the contract took place, means lex actus. Where the breach was committed, lex causae, where the cause of action arises, and where the court or settlement of the dispute sits, means lex forum. So these are all the things here there. If the subject of the dispute, it depends upon the subject of the dispute. If it is a land which is a immobile property, at that instance, automatically domicile will not function, contract where it is filed is not function, and where the case is filed is not function. It is the only the where the subject matter is situated that will be connecting factor, because land area is and the connecting factor for the land which comes under the immobile property, then we can say the lex situs could govern over there. That is the connecting factor over here. So even if it is differs from the domicile of either the party of the both the party, so there is the domicile of the party will not be considered over here, but on the land where it is situated, that will be considered. Is it clear? Dorcas? Because other people are LLB students.
Yes, Prof.
Because they are LLB students,
Yes,
of course,
Prof, it is
yeah,
clear.
I appreciate. Okay. Now comes to the part is of the criticism of the international law, how the criticism has comes. So what is that coming over here is where the subject matter is there, that connecting factor will be used, but not any other. So that is the international law theory makes it out. So criticism of the international law theory, how it can make criticism, let us see. Criticism of international law theory is that the international law theory was not spared of criticism. The main basis of such a criticism was that fact of the Savigny assumed the law of the different lands to be uniform. Of course, the law of the land of the not uniform, because the land law of the Tanzania is different, land law of the India is different. So lack of such a uniformity in practical world makes the theory less reliable. The point is the land law varies from the country to country. Suppose if you use such a where the land is situated, that country law would may not be suitable for the parties, those who are contract. So sometimes it will injustice to the parties, and hence the criticism comes over there. So because of the lack of such uniformity, there is no uniformity in the land law, but there is certain uniformity in the law of contract, and sometimes in the IPC also, because Tanzania is a common law country and India is a common law country, and we took all the laws from the England. So that is the reason we will find a lot of similarities should be there. A person who is teaching in India easily can teach in Tanzania, but a person who is teaching in Ethiopia or Eritrea, and it is difficult for him to teach in Tanzania because, tell me, because tell me, if you don't know, you say pass on, I will give you the answer. Dorcas, if you don't know the answer, you can say that pass on, I will give you the answer.
Please repeat the question.
See, a person who is teaching in India,
I didn't hear the question properly, Prof. Please repeat.
why you are there? Because I'm okay. I repeat the question. A person who is teaching in India can easily teach in Tanzania. I repeat, a person who is teaching in India can easily teach in Tanzania. But a person who is teaching either in the Eritrea or in the Ethiopia, for him it is difficult to teach in Tanzania. Then why? That's my question.
Because both India and Tanzania are common law countries.
Okay. Why it is difficult in other statement?
Such other countries are not common law countries, they are civil law countries.
They are, you say clearly, Ethiopia and Eritrea is the civil law country because their system is different. Hence, it's difficult for him to teach in Tanzania. That is the appropriate answer. Okay, let us go further. Lack of such a uniformity in a practical world makes the theory less reliable. Such is so because the lack of such a uniformity will render difficult to determine the natural seats of the legal relationship. So uniformity is very difficult to make it out. Even today, there is not a single system which will control the human rights in the world. That is the way a regionalism is made. American another region, European another region, and African other region, and sub-region all in the Middle East also there. For example, in many countries, a breach in marriage contract is considered a tort. The example which is given is, in many countries, a breach of a marriage contract is considered as a tort, while in other, it falls under the contract law. What about in Tanzania for the breach of a contract of the marriage? Yes. Is it a tort? Is it a contract? I repeat the question. For example, in many countries, a breach in a marriage contract is considered as a tort, while in the other, it falls under the contract law. Tell me now, if any person make a breach of a contract in Tanzania, is it a tort law? Is it a contract law? That's my question. Yeah, it's open to everybody, including the LLB students also. Yes? Dorcas, you are supposed to give the answer. If you don't know the answer, you say pass on.
I said contract.
Is it a contract?
Contract.
Suppose think that A proposed to marry B. A proposed to marry B, but he made a breach. Is it a written contract is there between them? Is it a written contract is there between them?
There is no written contract, Prof.
When there is no written contract, how do you
written
say it's a breach
contract.
of contract? Okay, now I will give the answer for that.
Contract can be.
It cannot be a breach of a contract, but it may be considered as a tort. The reason is I will tell you. See, he made a proposal that I am going to marry you. Yes. And these bride side people, what they did, they made all the arrangements. They purchased the rice, they purchased the sheep, they purchased many other things for the arrangement of the marriage, and the expenditure they incurred more. At that instance, they say that, see, you gave the promise that you are going to marry my daughter, but we incurred all of the expenditure over there. Even we printed the invitation cards also. So all this expenditure would be there, and hence they will file a case for the compensation and for the damages, and the damages comes under the tort. Is it clear? Is it clear?
Yes,
Want to
Prof.
get the compensation for the amount they incurred to conduct the marriage of their daughter. At that instance, and even a bridegroom also told to everybody in the class or in the office or anywhere that I am going to marry a particular person. Is it not a stigma there? Why he did not marry you? Because you told that you already that fellow is going to marry you. So it's a stigma on our part. That means there's something wrong with you. That's why they denied you. So many other factors are there. Hence, they can file a case in that law of tort. So that was the reason that in the way person make a breach of contract, a breach of a marriage, if there is no, it's a oral thing only. Suppose if it is a written one, in case it is a written one, of course, at that instance, we can file a case in the contract, because in the contract also there is a damages are awarded. In the contract also, damages are awarded. But when you compare the damages in tort, it is more than the contract. Okay? Situation varies. If it is a written agreement, it is a breach of a contract. If there is no written agreement, it refers to the tort. Because negligence was there, and hence when the negligence ingredient comes over there, automatically it turns to the tort. Is it clear?
Yes.
Okay. Now these are the criticism would be there. So better, less, that much is enough for that one criticism. You need not worry, because he has given the another criticism. Okay, let us see that, because what he gave the another criticism. Let me see it. Why you should have to go there. The international theory was not spared for criticism. The main basis of that is where we are. Yeah, up to this extent we did it. This theory also fails to recognize common law system and factors like religious diversity and ethnicities and custom which affect the various laws of diverse lands. For example, India is a country rich in culture and ethnic values like Tanzania. Thus, such a diverse nature of the country affects its laws within territory as they intricate as from a village to village. See, in this country also, if a man died over there, before that he will be cremated, not cremated, he is buried. Either the elder or the younger should have to marry that wife who's a deceased wife. In which culture it is there? In Tanzania? Did you understand my question?
No, can you
No.
repeat?
See, there is a culture would be there. If a man died in a particular religion, clan, before he could be buried over there, one of the brothers should have to get BBC with the widow. Then only the deceased can be buried. In which culture it is there? I ask the question, either you know it, you tell me. If you don't know it, you pass on. Because that I read it.
Pass on.
It's the which clan? See, there is a clan is there
Pass on.
there is a clan
Pass
is there
on,
in
pass on.
Tanzania. Because I read it. A particular clan, they will not bury him unless one of the brother should have to get the BBC with the widow. That is the culture would be there. Okay, let me give the another culture. The gay marriages are allowed. The culture is here. Even in India
No.
also there is no such a culture. So here one point is very much clear in the international law when you see it. Suppose the natural resources are there in your land. At that instance, the government should have to pay the compensation to you, a certain compensation, but the government can take that land, acquire the land under the Land Acquisition Act. But in the international instance, they clearly mention if any natural resources should be there, a person who custodian of that land would be the owner of the land. But naturally, that no one could be the owner of the land in Tanzania because only the custodian of land, because the government can acquire at any time any land, provided they will give you the certain compensation. What I want to impress upon is ethical culture is different here. See, the culture is in Islamic country or in the why Islamic country? Yeah, it is Islam. In the Islamic law, if a woman died, if her wife died, then he can marry the wife's sister. But he cannot marry the wife's sister when the wife is alive because they will not allow it in such a manner. Even though in Islam there will be 4 marriages will be conducted. So one country's ethnic and culture is different from another. Suppose I give the defamation because tomorrow I am going to deliver the lecture for the LLB 3YDC, the LLB students, the culture I am seeing, damages, the defamation is concerned. In Tanzania, a woman can have a children without marriage. Do you agree? Do you agree?
Yes.
Yes. But in
Yes,
India,
Prof.
if you just merely says to a girl or a woman, not we don't say woman, a girl, that so and so girl has delivered the twins, but she is not married. If you make such an allegation, false truth, it is amount to defamation. It is amount to defamation, even a slander, because the defamation there is a libel and slander is there. Libel is a written and slander is Dorcas. Slander is
Oral.
oral. If you say merely oral, a particular girl is a pregnant. If you say such information to other people in the presence of that girl, and the other people heard it, that is called publication. It is amount to defamation. But in Tanzania, it is not at all a defamation. So the culture varies and the practice varies over there. And hence we can say the international theory will not be applicable over there. So let us go to the territorial theory. What is territory? Can you tell me, anybody? What is meant by territory? Yes? What is meant by territory?
It's an area.
Define the geographical boundaries.
A boundary of a country. In other words, we can say jurisdiction in the court. In the matter of the court is concerned, jurisdiction will say. And the matter of the law is concerned, territory. The Tanzanian law will applicable in the territorial of the Tanzania. Is it clear? That is a territorial theory,
Yes.
or theory of the acquired rights. We can use both the terminology, either the territorial theory or the theory of the acquired rights. Now let us see the theory of the acquired rights, as called by many scholars, or the territorial theory, had laid its foundation when Dutch jurist Huber, H-U-B-R, Huber, propounded this theory back in 17th century, and this theory bases itself on the concept of territoriality. Territoriality, territoriality. However, it was developed later on by a common lawyer like the Dicey and the Bailey in England and USA respectively. Because Dicey from which country? Which place? Dicey. Dicey is from which place? India, sir. Or Dicey is from Tanzania, sir. Dicey is from England and the Bailey is from USA. It is clearly written here, but you are not giving the answer to my question. That means, could you able to see my screen? I repeat the question. Could you able to see the screen? Say yes or no.
Yes.
But why you?
Yes, Prof.
When the screen
Yes.
is very much visible to you, when I ask the question and you did not give the reply, that means your concentration is somewhere, I believe. See, I read like Dicey and Bailey in England and USA respectively. Then ask Dicey belongs to which place or which country. You have to say it's England, sir, and the Bailey is USA, because respectively is here. Is it clear? Say yes. Say yes.
Yes.
Or no. Okay, the theory is most simple words that the courts of a sovereign states don't apply a foreign law, but merely recognize the consequences of a operation of the foreign law. Any country will not follow the other country law. They want to follow their own country law, but the country law is the same like the other country, then it can be taken as, and there is no controversy. I told you, no, the other country law will not be considered in Tanzania when it contradicts with the statute law of Tanzania, or the policy of the contrary to the policy of the Tanzania, or contrary to the articles of the Constitution. So here they say don't apply foreign law, but merely recognize the consequences of the operation of foreign law. This means that courts of a country, according to them, apply a foreign law only to the extent to which they are permitted to do by the sovereign. The same thing that he said, okay, you can apply the foreign law, provided, yes, condition, tell me, you can apply the Tanzania, you can apply the Kenyan law, you can apply the even Indian law, provided, yes. What are the conditions?
Pardon, please.
Yes. Niagara Sabato Samuel. I don't think that.
Pardon, Professor.
Yeah, because you cannot understand it, because it's a private international law and you are in LLB only. And did you read the private international law? Did you complete the course of private international law? So here the question is, the other country law can be used provided that country law would not be contrary to the Tanzanian law where you are using it, number one. Number two, it will not affect the policy of the Tanzania. Number three, it will not contradict the constitution of Tanzania. These are the three conditions are there. The same thing is said. This means the courts of a country, according to them, apply the foreign law, means use the foreign law only to the extent to which they are permitted to do so by the sovereign. That means the sovereign will permit only to the certain extent, and sovereign will not permit if it is contradictory with their own policy, if it is contradictory with their own statute, if it is contradictory with the constitution. So that is the thing where the territorial theory will be used over there. In effect, it means that judge cannot by his will apply any foreign law. He cannot apply any foreign law or a judgment to any case he is deciding. He is essentially has to use the law of his land to govern all the cases that require his decision. So now the question comes over there. You are not supposed to use the foreign law. You have to use the domestic law, but where it is a very injustice caused to the other party, at that instance, without contract to their own laws, they can use the foreign law. But not, that means they discourage. They discourage means they discourage to use the foreign law, but encourage to use the
Foreign law.
they say discourage to use the foreign law, encourage to use the territorial law, means municipal law. Is it a confusion? It affects mean that judges cannot by his will apply any foreign law or judgment to any case he is or she is deciding. He essentially has to use the law of his land. What is the law of the land? Municipal law. To govern all the cases that require his decision. But if the foreign law, if the local law is not sufficient to decide the case, at that instance, okay, they can consider the law of the foreign law. That may be the thing here. So in other words, they discourage to use the foreign law, but encourages to use the municipal law, that is the land law. That is the use of the land, means country law of the land, means municipal law. So the application of territorial theory, in the theory acquire the right of territorial theory rights, reconcile the territory of need for the private international law. But in the most cases, better use the law of the forum. So let us see the discuss. Yes, read this. Unmute and read this one. Dorcas or other person. Read this one. The case law, which I am highlighted here. Read.
In this case, it has been applied in the case of Dalimple versus the Dalimple by Sir William Scott.
Okay.
In this case, the question of conflict was whether or not Miss Gordon was the wife of Mr. Dalimple.
Okay.
To tackle this issue, Sir William had said that the cause is being entertained in an English court, thus it must be adjudicated according to the principles of English law applicable to such a case.
Good.
But the only principle applicable to such a case by the law of England is that the validity of Miss Gordon's marriage rights must be tried by reference to the law of the country, where if they exist at all, they had their origin.
So here the question comes. When a case is filed over there for the divorce, or whether the marriage is not divorce, the marriage being entertained, whether the valid marriage or not, was the wife Mr. Jab to tackle the issue? What is the cause is being entertained is an English court, that it must be adjudicated according to the principle of the English law. Suppose if the marriage is a valid marriage or not, the English law should be followed over there. But again, they put the but only principle applicable to such a case by the law of England is that validity of the Miss Gordon's marriage, the right. Whether the Gordon's marriage she is having a right to marry must be tried by the reference to the law of the country where she belongs, where if they exist at all, they had their origin. See, now question comes. Gay marriages are allowed in South Africa. Okay? Right. Can you go to the South Africa and get married and come back to Tanzania? Just tell me. Tell me. Either you say pass on.
You can.
No. From Tanzanian will not go to the South Africa. With the South Africa allowed to marry the gay marriages. If you marry there, then they see it. Can your country allow it to marry? You the right to marry? That is the question here. Can your country will allow you to marry? That also be seen. If your country will not allow you to marry and you are not supposed to marry here, first they will ask, because he is an origin of the Tanzania, domicile of the Tanzania. Okay, now if you change the domicile of the South Africa, then he is a subject of the South Africa. When he is a subject of the South Africa, he can marry. Is it clear?
Yes.
In another way, it is a disguised form of getting permission to marry. Do you know concubine? Anyone? I can spelling say
Yes.
Concubine. Concubine. Tell me. Please tell me. Sir,
Concubine is someone who is in relationship with a married person.
yes. Can you say machumba in Kiswahili?
Chumba, not machumba.
It's a chumba. Okay. Can we say chumba? If any country would be there, yes, if you can marry a girl of particular country, at that instance, you can also marry, not marry, one girl is free to you, given in the form of a concubine. That is the country law. So can we go to that country and marry and get another extra, like the Nauza Hapa? If you buy one pant, trouser, one trouser is free. Is it clear? Is it clear? If you marry a particular country girl, so one girl is free to you as a chumba. So whether such a thing will be allowed in Tanzania? Suppose if you are a Tanzanian going over there to marry, answer is your country will not allow from where you are origin, hence you cannot marry. Okay, you can marry at that instance when you become a citizen of that place, the country. Is it clear? Is it clear? Say yes
No.
or no. Say yes or no.
It is not clear, Prof.
You are a Tanzanian. Yes. You are a male. Yes. You may go to that South Africa. And South Africa allows the gay marriages. Can you make the gay marriage? Conduct the gay marriage over there and come back to Tanzania and stay here? Tell me. Answer no. The reason is when you are going to marry according to the tradition,
No.
when you are going to marry in South Africa, they will use the territorial application theory. That is the territorial theory. Whether your country will allow you to marry. When your country is not allowed to marry, you are not supposed to marry. Okay, you can marry it, provided you will become a citizen of this South Africa. Is it clear now? Is it clear now?
Yes, Prof.
This is a territorial theory. Where you are living, where your country origin, whether that it allow you to marry, then only you can marry. Otherwise, you are not supposed to marry. Okay, you can marry, provided you are a subject of this country, means become a citizen of that country. Change the domicile and make a citizenship over there and get married. So therefore, the Sir William Scott has applied the theory of the acquired rights to decide in the case. Did you have acquired right in your country when you are going to marry in another country? Or you want to do any transaction in another country? That will be considered, and that is the criticism of this territorial theory. Of course, it is also given many other point also, but one example is enough for our understanding. Of course, there is the criticism also there made by the people. What the criticism made by the territorial theory? They said this particular theory has been highly criticized by Dr. Charles, who called it to be a unnecessary, untrue, unhelpful. It does not garner a lot of significant support in the present times either. Now the question comes over there. One should not to do a particular thing which is against the nature. That is the number one. I repeat, one should not do or perform an act which is against the nature. Gay marriages are against the nature. Am I right?
Yes.
So such thing will not be allowed. So what the same thing is that is unnecessary, untrue, and unhelpful, where the law of the diverse lands tend to differ from each other. It becomes rather impossible to tally the different lands, which either in many cases, for example, Nigeria. Let us see what is the Nigeria example he has given. Where British had ruled for ages, they still use the English law, thus making their legal system tally with that of the British, but such is not possible with every other nation. See, Nigeria still are using the mostly British law. Can it be possible for other nation to use the British law here? Can the Tanzania will use the British law entirely? Answer no. They will modify it according to the custom, according to the what I say culture of this country, and they will keep even a religious, cultural things in the law. Like how many types of the marriages are there in Tanzania? How many way the person can marry in Tanzania? Please tell me.
There is marriage.
Proceed. How many ways a Tanzanian can marry in Tanzania? If you don't know, you say pass on. I will give the answer. Oh, being a Tanzanian, you don't know how many ways that according to the Marriage Act, Tanzanian Marriage Act, or whatever the act would be there are three ways are there. One is a civil marriage, another is a religious marriage. What is the third one? Registered marriage.
Customary.
What is that? Customary marriage. Yeah.
Customary.
Customary marriage, religious marriage, and civil marriage. There are three types of the marriages are there, and all of them are valid. All of them are valid.
Marriages.
Valid marriage. So that is the thing would be there. The foreign judgment and their application are the part of legal system. Therefore, it cannot be neglected. So now we cannot in toto follow the British we will make the modification here and there, and which is suitable to the country, they will make it out. So the territorial theory is, in essence, nearly defeat the purpose of the private international law as a subject area where it was so possible to decide all cases with the use of the territorial law, then such debate would not take place. So sometimes the territorial law will not solve the problem because people of a different nature would be there, and hence, if a cause of action has happened in another country, naturally, which will the benefit to the party, and that thing should be done over there. And I already told you that it is the logic used by the judges to see that how how the justice would be done, and it seems to be done. So there is no hard and fast rule in the private international law. Sometimes you use this theory, sometimes you use that theory, which will give the benefit to the parties. So these are all the only way. Again come local law theory. What is the local law theory propounded? Walter Wheeler Cook is called as a developed version of the territorial theory. It is nothing but a territorial theory. Modified form is local law theory. He says you cannot use the other law, you should use the local law only. Let us see what the Cook says. Cook emphasizes on the fact that the governing rules should not be derived from the logical reasoning of philosophers or jurists, but observing the previous decision of the courts. He basically emphasized on the importance of the precedents. So a logical view cannot be used by the judges, but the precedents can be used. What is meant by precedents? What is meant by precedents? Yes, I asked the
Precedents.
question and somebody has
Decided cases.
already decided cases. Why you are taking so much time to give the reply? So according to the Cook, he say every court is essential to formulate its own set of rules based on the previous judgments. Whatever the previous judgment says, that would only to be followed, but not the new thing should be inculcated or it will be inserted. However,
Pardon, Prof.
unlike the territorial theory, for reason of the social expediency and practical convenience, it takes into account the laws of the foreign country in question. The court creates its own local rights, but fashions it nearly as possible on the law of the country in which the decisive factors have occurred. That means better we will give the local law importance rather than the using the foreign law. That is the theory it says. So he based his reasoning and theory on the fact that the lawyer is investigating the practice is how judges have acted in the past, how they have given the decision in the past. In order, it may be prophesied how they will be probably act in the future.